Hey everybody, I'm Luke Neerman, an immigration attorney here at Joseph & Hall, and today I'd like to give you a quick overview on who you can sponsor for a green card through the family-based I-130 petition process. So there's two categories of sponsors. We have U.S. citizens and permanent residents, meaning folks who have a green card. Now, as a U.S. citizen, you can file a petition for a spouse, a parent, or an unmarried child who is under the age of 21. So those three categories of individuals, those are called immediate relatives. And under US immigration law, there's certain benefits for immediate relatives. We're not going to get into all those details today, but the biggest benefit for immediate relatives is that there's an unlimited number of visas available, meaning there's no wait. You just have to wait for the petition to be processed. For all the other categories of folks that we're going to talk about today, Congress has imposed limits, caps on the number of visas that can be issued each year. And so depending on the family relationship, sometimes there can be pretty lengthy backlogs. So we talked about immediate relatives, but as a US citizen, there's a few more people you can petition for. You can also file a petition for children who are over the age of 21. And it doesn't matter if they're married or single. You can still file the petition. You can also file a petition for a sibling of a US citizen. Now, if you're a permanent resident, your options are a little more limited. So as a permanent resident, you can only file a petition for a spouse or an unmarried child. It doesn't matter if they're over 21 or under 21, but if they're married, then they don't qualify. So it's only unmarried children of permanent residents that can benefit from one of those petitions. And finally, I just wanted to make a note about stepchildren and step-parents. So what a lot of people might not know is that in some cases, a stepchild can file for a parent, or a step-parent can file for a child. So under US immigration law, a step-parent, stepchild relationship, it's automatically created when certain conditions are met. Basically, if a child's natural parent marries a step-parent and the child is under the age of 18 at the time that that marriage occurs, then under US immigration law, there's automatically a step-parent, stepchild relationship that's created. And if there's a relationship there, then a step-parent can file a petition for a stepchild as if they were a natural child, and vice versa. So that's a benefit that a lot of people don't know about that could really help out a lot of families. So that was just a really quick overview today of who you can file petitions for. If you have questions about your specific case or any immigration matter in general, we'd be happy to meet with you to talk about that. Just give us a call and we'll get a consultation set up. Thanks.